Finding the Lesser Magistrate on Friday, November 19th, 2021. And this is Staff Sergeant Robert Allen Retluski, U.S. Army veteran, also known as Rob Ryder, whose email address is courtofrecord@aol.com. No S's there, right? No courts of records, just courtofrecord@aol.com. And if you didn't know, there's this doctrine of the lesser magistrate, which is a concept of Protestant thought. A lesser magistrate is a ruler, such as a prince, who is under a greater ruler, such as an emperor. The doctrine of lesser magistrate is a legal system explaining the exact circumstances that a lesser magistrate has the right responsibility to resist the greater ruler. The doctrine of the lesser magistrate is dependent on private citizen argument from prior to the Reformation, so that'd be the Catholic argument, which stated that any evil done by an office holder is committed as a private citizen rather than by an office or by the office, right? So the state isn't causing your problems, right? Or the state isn't the one abusing you. It's an office holder as a private citizen, right, hiding behind his office, but he's doing it as a private citizen. All right, so both the private citizen argument and the doctrine of lesser magistrate were used in the United States Declaration of Independence to justify resistance by lesser leaders who are, in all other cases, would be bound to submit to the top executive. All right, well, that's fair. So, who are these lesser magistrates? And, just funny is how this stuff works out. Just here recently, I saw a short clip of a video about a guy who actually wrote a book about the lesser magistrates, maybe 5, 6, 7 years ago now, right? But it was geared towards the churches, right? And that isn't, and while the churches have gold fringe flags, and I say that, the guy in there technically is a magistrate of the military government that runs the United States, that's what the flag is. I mean, it's a military flag. That flag can only be displayed in a military office. Right, and I showed in previous videos that the churches got a commission from the military back in the First World War, and the commission came from the War Department. It didn't come from Congress, right? So they still have their commission. That's why they have gold fringe flags, but they don't want to use them. Well, but nobody else does either. I mean, your township hall, they have one, right? Your township supervisor has one. Your county commissioners, they have one. The governor has one. All these people have gold fringe flags, but nobody seems to want to call on its authority. Right? That's how you call in the military. Or, the general. So, how does that play out today? Well, that's what we're going to look at. This is my version of what this all means. And we're going to use a particular set of facts, and I'll show you what we found, and, we'll see where it goes from here. So hang on a minute and we can get started. Okay, so first of all, it should be no great surprise, right, that if it had to be someplace, it'd be in the court. Well, right, the lesser magistrate, then, I believe, is in the civil division. Now, this in Michigan, we call them the district court, right, but it's the court that has small claims cases, right? So basically, they have, general civil cases, landlord-tenant disputes, small claims, marriage ceremonies. This particular branch right here, not anything else, not the criminal court, not the big court, nothing other than the court where you would go for small claims, except you're not necessarily going there for a small claim. You're going there for a general civil case. Right? So, or it could be a small claim. It just depends on what the situation is. So, so I'm helping somebody in Michigan, and this is where we went to. It's not this particular court. I just saw the way they had it online, so I'm looking at it. But, in Florida, I believe they're called the county court. New York, well, what do they call it? What court has small claims? It's the only thing you have to answer first, without worrying about anything else, is, well, what court has small claims? Period. Go find out, and that's the court I'm talking about. And somebody in that court, doesn't necessarily have to be a judge, but somebody in that court has, this lesser magistrate authority. and I'll show you how we found it. But before I do, I got to do one quick sidebar, right? How many saw where the judge in Rittenhouse's case, right, referred to the Bible about the trials of St. Paul? Well, you can find this, right? It's actually in the Bible. How Rittenhouse judge explains hearsay rule to the jury by talking about trials of St. Paul the Apostle. Well, that isn't the only thing he talked about. He did talk about the hearsay rules. But, the judge said more than that. And like any other Esquire-driven entity, like the media, right, they only tell you half of the story in their headline. But basically, the judge had said, right, that, let me go find it in here. Then came the biblical monologue. This is actually referred to in the Bible. St. Paul, when he was on trial in Caesarea, was accused of some activity. And he was a Roman citizen, which is not common, but happened to have been. But he happened to have been a Roman citizen. So he had rights that we share now as Americans. Right? So this man is saying that your rights as an American come all the way down from the Bible, that you are the same as a Roman citizen if you claim it, which Paul did. When he was tried to be put him on trial with evidence from, which was being repeated by someone who wasn't there, and under oath, he said, "Where are the witnesses against me? I'm a Roman. I have a right to confront my accusers." Right? He claimed the jurisdiction. So either he's saying right now, you would say, I'm an American, I have a right to confront my accusers to end this craziness like Rittenhouse is going through. Right? Because Rittenhouse never claimed these things. And his attorney made sure he never claimed these things. His attorney should have done this for him, but he didn't because he's a fucking Esquire. And Esquires are crown agents. They're working for Britain. They're not working for the United States. Right? They should be here. And that led to actually his voyage to Rome to have his case heard before the emperor. Right? But he could have been let go. This is the point. You read the Bible. He could have just as easily been let go, but instead he said he wanted to go to Rome and face his accusers. Or have his case heard by the emperor. Right? But if you read the Bible, they were ready to let him go right then because they had mistakenly imprisoned a Roman citizen. Now, they didn't know he was a Roman citizen until he said he was. So when you go to court, they don't know you're an American until you say you are. I'm going to say I'm a citizen of the United States of America because that's what it says in the Constitution, and I can find it. I'm not, that doesn't bother me. I'm a lowercase citizen of the United States, not United States of America, of the United States. Lowercase citizen of the United States. Not United States of America. That's King George's jurisdiction. That's the democracy. Right? Citizen of the United States is under the Republican forms of government that were guaranteed to all the states in the 4th article of the Constitution. Okay. Has nothing, well, it has a lot to do with everything, but it has really nothing to do with this, what we're going to talk about next, but I thought it was quite interesting. Alrighty, so anyways, in my time since my last video, I had been, poking at the Department of Veterans Affairs because of this particular section that's in the Code of Federal Regulations, which is, in this case, 38 CFR, Code of Federal Regulations, Section 2.3, delegation of authority to employee to take affidavits, to administer oaths, etc. And I've shown this in videos before. Shit. And so it says in here that, the Secretary of the VA can delegate authority through certain sections of the United States Code, right, that they can administer oaths, and then any such oath or affirmation, affidavit, or examination, when certified under the hand of such employee by whom it was administered or taken and authenticated by a sealed Department of Veterans Affairs, may be offered or used in any court of the United States and without further proof of the identity or authority of such employee shall have like force and effect as if administered or taken before a clerk of such court. All right, so basically they're making an employee the deputy clerk of, the District Court of the United States. Okay, so I said, okay, I want to do an affidavit about the things I'm complaining about. I don't want to do it with a notary seal, right? If I can get this seal, I'd much rather have this. Well, come to find out, of course, they haven't appointed anybody. I call my local VA hospital. They haven't appointed anybody. You want to know what my complaint was about? I said, well, you're using like 5 different variations of my names, or my name, in these records that are supposed to be confidential and protected. Right? They got Rutluski, Robert A, Rutluski, Robert Allen, Robert Rutluski, Robert A. Rutluski, Robert Allen Rutluski. Right? This one's got this name, this one's got that name, this envelope has this name, but the letter inside's got this name. All sorts of shit. They're still doing it to this day. Well, what do you do about that? So, I have been working on this stuff myself. Well, I got a call from a lady named Tammy who was having an issue with the IRS, which is something I had, always kind of wanted to get it. I just never really looked at some of these papers. And so I said, yeah, well, go ahead and, just send me something. I said, you don't have to send me everything. I just want to see what they did wrong, right? So I was already having this in my head that, what I want to do with this is, because this is happening, I want to complain against the United States. Let's look at that first, right? So, right, and so could I do it? We'll look at Tammy's stuff in just a second. But hang on a second. Yeah, so I went, looking to see what you could do with the United States in a court. And under Title 28 of the United States Code, so 28 U.S.C. 1346, it says United States as a defendant. The district court shall have original jurisdiction concurrent with the United States Court of Federal Claims. Now, notice that this district court isn't capitalized. It's not the proper name of a court. But they did use a proper name of a court here. Right? So which district courts are these? Wow. Any civil action against the United States for the recovery of any internal revenue tax alleged to have been erroneously or illegally assessed or collected, or any penalty claimed to have been collected without authority, or any sum alleged to have been excessive or any manner wrongfully collected under internal revenue laws. Okay, so whatever that is can be heard in the district court. Civil action against the United States for the recovery of internal revenue losses. So it didn't say to go to the U.S. tax court, right? It said to go to the district court. All right. Well, if things were erroneously or illegally assessed and collected, right? Well, that just became an intentional tort. Now it's not really about the taxes. It's about the tort, the damages caused by the intentional tort. And, the way they do it, by definition, it's a malicious prosecution, which is an intentional tort covered by general liability insurance. I got a policy. It has it in there as, one of the things that's covered by the policy. And it covers $1 million, per occurrence. Or $2 million if you pay more. So it's in there. It's like, well, there's intentional tort right there. Or, malicious prosecution. That's what we should do with the United States. So as it turns out, that's why when I got this call about IRS, I said, hey, that fits in. We could take it and try to do something with it, making the United States a defendant. Right? So any other civil action or claim against the United States not exceeding $10,000 amount founded on either the Constitution or any act of Congress or any regulation of any executive department or any expenses or implied contract in the United States. So I started to find out if you start looking at these laws close enough, you'll see that certain ones have penalties in them for a certain amount of money, or they say damages for a certain amount of money, and they're built right in. An example is the Fair Debt Collection Practices Act that covers every, plaintiff and their attorney that's taking anybody to court for foreclosure, right? They're doing the plaintiff says on the paperwork they send, they're doing it as a debt collector. Well, in that act, both at the state level and the federal level, there's a clause in there to have $1,000 in damages awarded because of, violating the act. Okay, well, $1,000 claim in Michigan, you could just do in small claims court. Right? In a small claims court, you're not supposed to have to be represented by an attorney and so forth, and da-da-da-da. Well, it turns out small claims is in the district court. You read about the district court, and it says it's supposed to be the people's court, and da-da-da-da. So it all sounds good. But I've tried to put shit in there before. It didn't do any good. But here I am reading it again, saying, okay, well, it says what it says. Right? So there's many cases for not exceeding $10,000, because you can determine those damages. And the point of that is that those damages are for the occurrence of the thing, not the damage caused by the occurrence of the thing. That can be handled as a penal damage, a statutory damage, or compensatory damage. They have all these different damages they can give you, by verdict. This is just to get the thing in the court. Right? To make the United States a frickin' defendant. Because the other thing, in the United States, or in Michigan, a malicious prosecution is a misdemeanor. So if you bring the United States to court and the United States loses, well, the United States just committed a misdemeanor. And the United States could go to jail for up to 6 months. Well, the person that will be the United States in the courtroom will be the attorney that the United States sends. He'll be representing the United States. So now his ass can go to jail. He would be the one committing the misdemeanor. So it just makes sense. Well, they're going to have to come ahead of time and settle, right? Which is really what I want anyways. I don't want to take anybody to court. I want to settle. I got an issue with my brother, the United States, and I want to get it resolved, right? And so this is done through the court that has small claims jurisdiction. Whether you make it a small claim, you make it a general civil, which is probably the proper thing to do, is a general civil, because then it can be all sorts of things. In Michigan, you can't do a small claim as and this was the problem. You can't have a small claim as a intentional tort. So my idea of doing it as a small claim fell apart because, well, I can't do an intentional tort as a small claim. I guess we'll have to do it as a general civil. Okay, jurisdiction for this section includes jurisdiction of any set-off, counterclaim, or demand, whatever, on part of the United States against the plaintiff, commenced action. Okay, so, of course, you could be wrong and they could be right, but, you're going to get your day in court. District court shall not have jurisdiction under this section of any civil action or claim for pension. So back to here, well, this is where the lesser magistrate's going to make a decision between the citizen and the nation state, right? Because they get to decide. You're having this in whatever this little district court is. I'm saying that district court is the court where small claims is heard. It's not the one called the United States District Court. All right, that's in the democracy. We're not in the democracy. We're trying to get to the republic. District courts have exclusive jurisdiction, all civil actions under some other section, acquire titles to estate, interest, and real property, in which the United States is claimed, an interest is claimed by the United States. Well, if you have a mortgage, the United States is claiming interest because it went through HUD. Right? Someplace in your paperwork, for most people, you got some kind of HUD paperwork. Make the United States the frickin' defendant. And they can go figure out who else screwed the pooch. But, you don't have to do it. You just say it's the United States' fault. Right? It's the king's fault, which really it isn't the king. It's his ministers. But I'm going to blame the king that his ministers have done it. And now the king has a duty to go correct his ministers and, take care of the damage that was done to me by his ministers. Right? And then in 1402, the United States as a defendant. So it's in two different sections as the United States as a defendant. Any civil action in district court against the United States under this subsection, section 1346, may be prosecuted only in the judicial district where the plaintiff resides. And as we'll see when I show it, when you look at the court forms they have for Michigan, one of the place, one of the entries it has is the judicial district. Like I'm in the 63rd judicial district. So it's like, oh, okay. Well, that's the court where small claims is. I'm not going to argue with it. Just, say, okay, well, that's what it says. Convince me some more. Any civil action on a tort claim against the United States under subsection B may be prosecuted only in the judicial district where the plaintiff resides. Well, okay. My tort claim is a malicious prosecution. In this case about the IRS we're going to look at. Right? It's a malicious prosecution. So that can only be heard in the judicial district where the plaintiff resides. 63rd Judicial District. 84th Judicial District. Whatever it is, right? In Michigan, there are judicial districts, but they don't have to be called that for it to be in your state to have the same thing. It's just the place where small claims court is. All right, so I'm not going to read all these. It'll take too long, right? But we got a section here about members of the armed forces sued or prosecuted. This is interesting. Or a civil or criminal prosecution in a court of a state of the United States against a member of the armed forces of the United States on account of an act done under color of his office or status, or in respect to which he claims any right, title, or authority under a law of the United States respecting the armed forces thereof, or under the law of war, may at any time before the trial or final hearing therefore be removed for trial into the district court of the United States for the district where he is pending in a manner prescribed by law. So in other words, if you say that you are, a member of the armed forces, you're protected by the Geneva Convention, which is a treaty of the United States, so it's the supreme law of the land, right? You demand trial by court-martial. They have to remove your case from wherever it is and take it to this other court. Lowercase district court. Because we're under a military government. Right? Whether you want to, wrap your head around that or yet or not, it doesn't change it. Whatever the government of the United States is, was put in by the military. Right? And it has nothing to do with what we call the democracy. Right? All the people in the democracy who are pretending to claim an office have not taken an oath to satisfy the 6th article of the Constitution. So, it's the fiction. Well, I don't want to deal with the fiction. I'm going to go to the real. In 1863, when President Lincoln declared martial law by suspending the writ of habeas corpus throughout the United States, you suspend one part of the Constitution, you suspend it all, we're under martial law. He had already written the Lieber Code and put it out. Lieber Code says you go under martial law. Nobody needs to tell you. There's no, nobody needs to tell you you're under martial law for you to be under martial law. But it does say that once martial law has been declared, which he did, that it doesn't end until there's either a proclamation by the commander-in-chief ending it, or it's in a treaty of peace. And neither of those have happened since as part of the Civil War. Or whatever they want to call it. Whatever that conflict is, however you want to say, it wasn't written. I don't really care. There was a conflict. It was armed forces against armed forces. Hey, United States under attack. Martial law was declared. It's never been rescinded. All right. So, obviously, there's actions affecting property on which the United States has a lien. Right? So if you want to quiet a title, foreclosure, partition, condemn, interplead, any of that stuff, well, guess what? It's heard in the lowercase district court. Which I'm saying, well, that's the court that has small claims. Even if you're not going there for small claims, I'm just saying, well, that's how you know which one I'm talking about. No matter what other jurisdiction it has, it will have the jurisdiction of small claims. Okay, very good. For those reasons, right, I wanted to try something in this court with this particular set of facts to do with an IRS case. And so if you have an IRS case, you should really pay attention closely. And if you don't, it doesn't change the fact that this is the idea you could use on your set of facts. And, I'll have more examples soon in the future. I'm not trying to, show everything at one time. So please don't send me your court case and say you want me to do something for you. No, you watch this video 3, 4, 5 times. Wait for the next video. Watch it some more. Watch it some more. Watch it some more until you've convinced yourself you can do it without me doing it for you. Well, then go file your paperwork. All right? And until then, hey, just watch and see if it works. I don't even know if this is going to work. I'm just saying this is what we're doing, and these are the reasons. So I don't want to do yours because I don't know if this is going to work. If you couldn't tell, I get asked quite often to do people's, court paperwork, and that's not what I do. So I may do a couple because I want to try something, and I'm dependent on who I'm helping to, bring me back information. And that's what's happened. Okay, so let's look at, hey, this is an IRS case. Let's see what caused it. Right, so, excuse me, Tammy contacted me because she's got an IRS issue. And, hang on just a second, please. All right, so Tammy had an IRS issue. And as I said, I was already trying to think of a way to make the United States a defendant in something. And I get it, she's calling me about this. And, she's got all sorts of letters and stuff from them. And I said, well, you don't need to send me all of them. Just send me, some things that show some things. Right? So, you may or may not have these exact letters, but you have letters that have the same things I'm talking about. So I'm just going to go through and show you some of the things to look at. Step 1, right? If you have an IRS issue is go get all that freaking paperwork they gave you. Right? It might be easier to have uploaded it online, but whatever. And start looking at it. And what you see is, whoever they're putting the claim in against, it's not your full legal name. Right? It's Tammy L. Blazek doesn't exist. There is nobody with that name. Yet, this taxpayer has her Social Security number. So that's like, well, that's identity theft. Right? Somebody just stole the Social Security account of Tammy Louise Blazek, right, in her full legal name. Anyways, so we're auditing your 2018 Form 1040. Right? Proposed changes to your 2018 1040. Dear Tammy L. Blazek. So obviously, they're not talking to the real person. They're talking to this taxpayer. And they said that they still owe a balance of almost $7,000. Well, who wants that in their life? And then they sent some paperwork to back up their claim, right? And the report of income tax examination charges. Right? Again, this isn't Tammy's name, but that's what they're using. And this person, taxpayer, did steal her Social Security number and called it their ID. How they get away with that, I don't know. Adjustments to income, you got state returns, credits, offsets, other income, wages, salaries, tips, etc. Yeah, that's what it says. And, right? So it all looks good. You keep going through this thing. Say, well, it's not me. Right? They stole my Social Security number. The United States stole my Social Security number and gave it to this other person, but it's not me. But the big thing is that, now this is what got mailed to her, right? Well, it has no tax examiner's name and it wasn't signed. Well, then, this doesn't have any value. How could you lose any property or have an audit over something like this? Well, it gets worse. They put in this other thing this information, and you can go and Google Form 6251, and they have a form for this. But this isn't the form. It's just the information that would go in the form. So they counterfeited the form. It's got all the numbers, got all the entries, but it's not on the form of the IRS. They made this fucking thing up. And yet they're calling it a Form 6251. Well, I'd say that's, illegal. And what else we got here? Well, same thing, right? Just not you using your Social Security number. Well, that's identity theft. Yeah. Every place, no place do they use your full legal name, right? They don't even know the full legal name exists because this fictitious taxpayer was made. Let me show you where he comes from. All right, so when you go to fill out a W-4 employee withholding certificate, what's the first thing it says? First name and middle initial. All right, so, you'd write Robert A. in there, right? Where, in fact, my first name is actually Robert Allen. I don't have a middle name, therefore I have no middle initial. So I should have just, put in there Robert Allen. Right? Last name Ratluski. But we don't do that. So, there's a very good chance that you created this monster in your first, by yourself, by putting on a withholding certificate a middle initial. Right, and the problem with that then is, well, that name doesn't match what's on your Social Security account. It has the number on there. So, a lot of this paperwork ends up going to Social Security. So they should say, hey, there's a mismatch here, right? This is where it's really not your fault. You made a mistake. And the government should say, hey, the name on your employee withholding certificate doesn't match the name on your Social Security number. But they didn't tell you. The United States didn't come and tell you there was a mistake. Well, that's, an omission of a duty. So, if you have an IRS issue, you have paperwork like this. Just go look at it. Now here's another one she got, a levy disclosure. Right? This says this from the Michigan Department of Treasury, FOD, and it gives this number. But you go look that number up online, and there is no such Treasury form or such form on the Treasury website. There is no M-1050. And as you can see, this is from 1992. Right? They're sending a 30-year-old form. And then it says on here that, the levying agencies, the Internal Revenue Service versus State of Michigan and Blazek, Tammy L., which wasn't Tammy L. Blazek, who was on the other documents. They just created another person. Right? But the State of Michigan is the defendant with this particular debtor name. It didn't say Tammy L. Blazek is the debtor. It said Blazek, Tammy L. Well, that isn't Tammy L. Blazek. You don't have any comma in your name. They want to put your name backwards. Then it should say last name, first name, middle initial or something. But it doesn't. It just said name a debtor. Well, this is the name, and that name doesn't match Tammy L. Blazek on the other document we looked at, because Tammy L. Blazek doesn't have a comma in it. So basically, I say this is the Republic, right? The Internal Revenue Service is representing the Republic, or they're supposed to, the United States. And this over here is the democracy, right? And Internal Revenue Service is asking the democracy for its money on a form that no longer exists, where the treasurer of the state of Michigan doesn't disclose anything. And then the state of Michigan owed the debtor this amount, debt in its personal services. I thought they were an employee. How does that make it personal services? I thought it was wages. But if you want to say it's personal services, then it wasn't wages. Right? So, these things that you might have to pay tax on just went away. Done by somebody using the middle initial name on a document that no longer exists. And right, to Blazek, Tammy L. at this street address with a zip code that doesn't match their zip code. Right? It wasn't the zip code they were using over here. All right. Here she's got 8542. Here's going to 0000. Here's Blazek, Tammy L. Here's Tammy L. Blazek with no period, no dot. Every jot and tittle. Okay, well, that wasn't the only paperwork. I mean, if you've ever dealt with the IRS, when they start sending paper, it doesn't end. Well, now we get this notice of levy of wages, salaries, and other income, where they're using this zip code that, what's the 204? Who has a zip code like this? It says the same for the Michigan. Michigan Dep of Treasury, Div, third party withholding, UN, with the 12-digit zip code. I understand there's 12-digit zip codes, but I don't see how these are 12-digit zip codes. right? If you read about the delivery point, the 12-digit zip code, 32 should have been part of this number. Anyways, right, it's to somebody who doesn't exist. Taxpayer. I don't know there was that much more in here that, because it's, oh, then they're this is what they're after, right, is these civil penalties. So now it has nothing to do with the taxes anymore. Now it's just penalties. Ching, 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 ching. Well, this sounds like a minister of the sovereign who's abusing their power. Well, and then finally she gets this notice of deficiency, right, to Tamiel Blazik, who doesn't exist, about needing to do something. And I think it says in here, just a minute. If you want to contest this determination in court before making any payment, you have until the last date to petition the tax court. 90 days from date of this letter, 150 days the letter addressed, blah, 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 blah. Okay, well, that's, if you want to contest this determination in a court before making any payment, you have until the last date of the petition, tax court, date to petition the tax court. Okay, well, that's not what we're going to do. We're going to take it to the district court. So that's what we did, right, is we took it to the district court. And, well, that's what this is about. This is what she got filed yesterday. I guess I want to show the original forms. Hang on a second. All right, so, like I said, in Michigan, they have these approved documents from the SCAO, which is the State Court Administrator Office, right, where it says Judicial District, which is the exact thing I talked about where you had to take the United States to sue them. So, and it had plaintiff's name and defendant's name, and you got to check a few boxes and so forth. So, right, this is for the summons, and then they have another document, which is for the complaint, right, which make your complaint and file your paperwork. So that's basically what we were going to do, or have done. But when we did it, it looked like this. Oh, I think I forgot to show the law when I was going through the stuff earlier. But there's a law, when you're going to make the United States a defendant, that then what you need to do is you need to, by certified mail, contact the Attorney General of the United States, right, and at a particular address, and then contact the United States Attorney's Office for your district. So that's what we're doing. We're using those addresses. You can go on the online and find your U.S. District Attorney's Office, or United States Attorney's Office, I should say, right? And see what the addresses are and figure out which one you can mail it to. And the address of the Attorney General of the United States is the U.S. Department of Justice's address, which is on the Department of Justice website, right? That's how you contact the Attorney General of the United States. That's what it says. So we're going to find out. And so this is what we did. Right, that was the summons. So all this stuff has been filled out now, and basically, right, it's got a court case number. Right, the court took the paperwork. We made the United States a defendant, and the court's taken the paperwork, gave us a court case number. All right, and so the complaint then, well, this doesn't have it on there. I don't know why this doesn't have a court case number. I don't know how they actually do all their internal documentation, right? But this is the complaint that goes with it, and all I did is put C attachment, right? But signed it anyways because I had a place to sign it. And then, for the meat and potatoes of the complaint, then complaint affidavit attachment, which I had shown in a previous few videos, right, where it had shown that if you're doing an affidavit, right, you put your state of Florida, county of, and then put this line before me this day appeared, whoever you are, being duly sworn, deposes and says. Then you insert your facts, and after your facts, you sign the bottom. Then you have this little part down here where the notary is going to say sworn or affirmed before me, right, acting as the official witness, right, da-da-da-da. Right, but, you know, you need to put your facts in here, right? So you shouldn't have this line and then this line without some facts in between. That's all I'm saying. And so that's what we did. And that's what I said then. So before me this day, personally appeared Tammy Louise Blazik, plaintiff, who being duly sworn deposed says, right? So that took care of the part about this, just showed you where you got your, basically your venues, and then you have that opening statement, and now you have your facts, right? So now if you've watched my previous videos, the last 5 or 6 videos, where I had shown that, you know, we had filed a couple months ago, I came up with this idea of, you know, filing a notice of constitutional question into a court case, and make the constitutional question based around the fact: do these people need to have an oath of office to satisfy the 6th article of the Constitution if they're going to be, you know, a judicial officer in your court case? And as it turns out, well, yeah, they have to, right? But a notice really isn't the right thing, right? Because it's a notice. And when I read it closer, it said there should have been some other document put in first that the notice was referencing. And so I said, okay, well, let's make that the evidence, and we'll call that take judicial notice of facts and laws, because the judicial notice is supposed to be evidence, right? So basically that's all this is. It's taking that information now and putting it on a form slightly different and calling it an affidavit. But this is what we said, right? That it's a fact that the plaintiff is a citizen of the United States and Michigan, protected by the Constitution of the United States, the laws of the United States and Michigan, compiled laws, and the court has a duty to take judicial notice of these laws. Well, that's what it says when you go look up judicial notice in your state laws. It says they need to take judicial notice of the laws of, you know, whatever jurisdiction that you reference in your paperwork. All right, well, as we'll see, let's see what it says about the Constitution. But first, it's a fact the United States is one nation under God with liberty and justice for all. It's a fact that the 6th article of the Constitution of the United States states that this Constitution and the laws of the United States, which shall be made pursuant thereof, and all treaties made or which may be made under the authority of the United States shall be the supreme law of the land, and judges in every state shall be bound thereby, anything in the Constitution and laws of any state to the contrary notwithstanding. So if I put that in here, and that's the fact, that's what it says, and then the judge agrees, well, then he agrees that's the fact, right? He's judging the fact. Unless somebody rebuts that, then the fact stands that that's what it says. And so if I bring in any law of the United States or treaty or anything else, well, then they have to take judicial notice of it. The same section, though, then says that the senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test should ever be required as a qualification to any office of public trust under the United States. It's right out of the Constitution, 6th article. Right? Well, it's also a fact that Black's Law Dictionary, 2nd edition, defines a judicial officer as a justice for the peace, magistrate, or judge, or any other officer of the court, and that Nolo's Plain English Dictionary defines officer of the court as any person who has an obligation to promote justice and uphold the law, including judges, clerks, court personnel, police officers, and attorneys, who must be truthful in court and obey the court's rules. It is a fact that an attorney is a judicial officer of the United States and of the several states. Right? So, stopping for a second. So, if any attorney wants to take you to court, he has to have taken the oath to satisfy the 6th article of the Constitution. Now, I didn't put it in this particular one. I easily could have, but that's in 1 Stat 23, right? 1 STAT 23, first law passed after ratification of the Constitution. An act for establishing the time and manner of administering certain oaths, I think is what it is. But, it's a law of the United States, and it says in that law that the following form is the oath that satisfies the 6th article of the Constitution. I state your name, do solemnly swear to support the Constitution of the United States. Period. That by itself got to be on some record somewhere that you did it, or you have not complied with the Constitution. And so, then the attorney is not, if he hasn't done this, well, then he's not an attorney, because an attorney has to have filed the oath. So it's somebody impersonating a public officer because he's claiming to be an attorney. So it is the fact that by use of simulated legal process, agents of the defendant are maliciously prosecuting plaintiff for payment of non-existent income tax and have seized her interest in property by levy without due process of law in offense of the Constitution of the United States, laws of the United States, and Michigan compiled laws. Right? Because that's what they're doing. You've already seen there's all these errors in there. Well, you know what that's called? That's called a simulated legal process. And she's being maliciously prosecuted by somebody, whether they're an attorney or not at this point. It's a malicious prosecution by definition, as we shall see. Right? Now, it's a fact that the IRS yearly publishes document 6209, ADP and IDRS information, and makes it available for viewing on www.irs.gov, the same being an official website of the United States. If you have an IRS issue, or you don't want to pay your IRS taxes anymore, you should probably go look at this. So you can say, hey, I don't have to pay these taxes. Right? It's called the document 6209. So let's see what happens when we look that up. Let's just go real quick. Right? So if you were to Google IRS document 6209, oh, there it is. Right? You can click on it, and you can look at all these different editions. You take my word, the parts we're looking for haven't changed. Right? And if you go to Tax Class 2, or Section 2, this is the section that lists all the different forms that you probably are involved in with the IRS. And it, puts them in a tax class. It's one of the, it does many things, but one of them puts them in a tax class. So if you look at a W-2, it's a tax class 5. Okay. How about W-4? That's a tax class 5. All right. How about a 1040? Well, that's a tax class 2 or 6, but it's not a tax class 5. So you could already stop and say, well, why would I put tax class 5 information on a form that's meant for tax class 2 or tax class 6? It doesn't make any sense. And you would be correct. And yet we do it anyways. Right? You could go further down, excuse me, to get all the different 1099s, and you can see that they're all tax class 5 also. I mean, most of these, 1095s, 1098s, 1099s are all tax class 5. So what does that mean? Well, it means they're not tax class 2, which is, what goes on a 1040 form. So why are you putting this information on a 1040 form? It just doesn't make any sense. Well, I know why you're doing it, because you're coerced into doing it. I get that, but, that's why we have the complaint, is, hey, you're forcing us to put information from a tax class 5 form onto a tax class 2 income tax form. There's something wrong with that. All right, so that's this. Then if you go to Section 4, right, and look under Document Locator Number, clearly identifies tax class 2 as individual income tax, fiduciary income tax, partnership return, and tax class 5 as information return processing, estate and gift tax. Right, Exhibit 1, Exhibit 2. So obviously I got a couple exhibits in here, which are just the same pages we're looking at now. All right, so that's, right, again, document 6209, section 2, and then document 6209, section 4. It's right on the first page. Where it shows how they make this format for this, and this, the third number basically, or the second box, I should say, third digit, is the tax class. And it gives all these different tax classes. Well, this is where you know what a tax class 2 is for, what tax class 5 is for. And they're not for the same thing. So don't be putting tax class 5 information on a tax class 2 form and turning it in. Just tell them you don't have any income tax. You don't have any forms that show that you have any kind of income tax. So that was, that's what we're arguing about. So it's a fact that the compensation identified on the W-2 is not taxed as individual income tax. Well, we just saw that. And the plaintiff has no source of tax class 2 income to report on a 1040 U.S. individual income return, because all she has is a W-2. Right? Or if you have 1099s, it doesn't matter. If they're tax class 5, it doesn't go on the frickin' form. It is a fact that the plaintiff is in receipt of numerous documents mailed by defendant's agents that prove the use of false records in simulated legal process, such as Form 4549, Report of Income Tax, dated the date and the name it's in, and so forth and so on. We made that Exhibit 3. Here, we'll show you one copy of what kind of shit you sent to us. It's a fact that the United States government has a fiduciary duty to citizens of the United States, and that the defendant is negligent in this duty for not informing the plaintiff of errors or omissions in official records of the United States that adversely affect the plaintiff's interest. So now, I've said it's a fact on an affidavit, and if it doesn't get rebutted, well then that's a fact. Right? It's a fact that the plaintiff was deceived into omitting her full legal name on the W-4 employee's withholding certificate by that form statement, first name and middle initial, which resulted in the creation of a fictitious named taxpayer, Tammy L. Blazik, claiming ownership of plaintiff's Social Security account. The defendant had a duty to protect plaintiff's interest and correct this error, but did not. Right? Because, again, some of this documentation from this tax shit all goes to the Social Security. And, they know the name on your Social Security account. They say, well, that name doesn't match Social Security account. They didn't. Right? Social Security is part of the United States. They should have told you, but they didn't. The defendant had a duty to inform taxpayer that W-2 wage and tax statement information did not belong in a 1040 individual tax return because it's not tax class 2, but did not. Blame it on them. Well, it's also a fact that under Section 2907 of the Michigan Revised Judicature Act of 1961, which is your Act 236 of 1961, the sum of $200 damages is owed the plaintiff by the defendant for its agent's malicious prosecution and other relief by verdict. So then our claim is the plaintiff's interest has been damaged by defendant's dereliction of duty, malicious prosecution, and seizure without due process of law, for which the plaintiff now seeks an award of damages due to malicious prosecution and a perfection of interest in the plaintiff's Social Security account, the return of plaintiff's property unjustly seized by defendant, and other relief this court deems just. Right? And so forth and so on. And then, ta-da, I got a seal on it. Well, that seal is real important. We're going to get back to it in just a second. I just want to show you these exhibits, right? Because you may want to do this. If you got a tax thing, right? I went and copied the 2 pages, right, that had the W-2 on it, because that's what she has. And the page that said 1040, right, that it's a tax class 4. But if you don't have W-2s, you have all 1099s, then go to the page with 1099s and get it. If you have 1099s and a W-2, well, then get both of those and this page. I'm just saying, this is the page here that says, 1040 form is for class 2 and 6, and the things we're talking about are class 5. Right? That's called documentary evidence. Right? And that section 4 says what all these different tax classes are for. We don't need to know anymore. Here's that exhibit. This was actually the first marked up document I showed that right? There's no examiner's name and there's no examiner's signature. And then finally, Exhibit 4, malicious prosecution. Right? Every person who shall, for vexation and trouble, or maliciously cause or procure any other to be arrested, attached, or any way proceeded against by any process or civil or criminal action, or in any other manner prescribed by law, to answer to a suit or prosecution of any person without the consent of the person, or when there is no such person known, right, Tammy L. Blazik, shall be liable to the person so arrested, attached, or proceeded against, and treble the amount of the damages and expenses which by any verdict shall be found to have been sustained and incurred by him, and shall be liable to the person in whose name such arrest or proceeding has been had in the sum of $200 damages, and shall be deemed guilty of a misdemeanor, punishable on conviction by imprisonment in the county jail for the term not exceeding 6 months. So, right, the United States could be found guilty of a misdemeanor, which would mean they're going to have to come early and settle the matter. Okay, so this was the complaint. Now we get down to the to the moral of the story. So this was the complaint that we put in. And excuse me, since I had an affidavit, it's like, well, you should go to a notary. In fact, we had it set up to go to a notary. But I had said to Tammy, I said, look, you get a notary, that's for private matters, but you can go to after you get the notary and go to the county clerk's office, and there's, at least they did back in the day, they would give you a certificate of authority that says that the notary was a notary, and, got a little statement they put on it, and that document has the seal of the circuit court of the county on it. Right? So it's a higher level of authentication. So, she did that, and she went, and she called me back and said, well, our first snag, they say they can't do it in the county clerk's office. So I'm scrambling around because I sent her and said, look, I know they could do it before. Here's what I did. And I'm looking for the law that said they can, and, getting a little bit frustrated because we already had this little snag. So then I called her back and said, well, look, the county clerk is supposed to be able to, administer you an oath. So just have her do it as the county clerk. Right? Forget going to the notary. Just say, okay, county clerk, then you administer the oath in this affidavit. Well, she said she couldn't do that either. Well, now it's like strike two at the clerk's office. How can you not, give us, give an oath when you're, the law says that you can. Well, the lady admitted, the guy or lady, I don't know who it is, admitted that, kind of new, don't really understand all this. Your first person asking these questions, I got to get some, get some help. Well, as she was doing that, I came up with a law that said that, that the district court magistrates can also give you administer an oath. Right, so, oh, shit. So just so we all understand, we're Missaukee County, where Tammy is, it's a sparsely populated county in the middle of Michigan. Right? I mean, this is the county courthouse, this little square box right here. Right? So, not at all very big. And in the right, and so in the court, right, they don't have that many people. They got a court administrator, magistrate, a deputy clerk, a probation officer, yada yada yada. So all this stuff, was right in the same area. I mean, the county clerk's office is just in the same building, just down the hallway from the district court. So I told her, we'll go down to the district court and see if the district court magistrate will do it. Right? So this isn't the district court deputy clerk. This is the district court magistrate. And there's only one that says magistrate. Right? One magistrate in this little, sparsely populated county in Michigan. I mean, you can't be much more of a lesser magistrate, but there you are. There is one. And so when Tammy went to have this done by that magistrate, right? She sealed it. Now, we had this all set up for a notary, so, this part may have to be redone a little bit so we get it done properly. Put a block here for the magistrate's name and so forth. But the important part is, you know what seal that is right there? Guess what that seal says? Although you can't see it here. And I have to take Tammy's word because she hasn't sent me a better copy yet. But I have every faith that it's exactly what it says. That seal says, the District Court of the United States. Right? It's the District Court of the United States. Let me type that out for you. Hang on just a second. This. The District Court of the United States. That's what's on the seal. On Tammy's affidavit. Well, if this person is representing, the District Court of the United States, then does that mean by filling out this paperwork here, which is saying that it's going into the 84th Judicial District, that this is the paperwork of the District Court of the United States? Right? Is that the proper name of the court? So it's a big deal. This is in the court that has jurisdiction over small claims. I went all through all this, right? Because I have people that I've been helping in their court cases. And it's not that I'm trying to do everybody's court cases, but you got to have something to work on to see what happens, right? So it's these people I'm expecting to go now down to wherever the small claims court people are in your jurisdiction and say who in the office has the seal of the District Court of the United States. I have business with that court, and see if they'll take you to talk to them. Right? I mean, I didn't know ahead of time that that's what was going to be on the seal, but once that's the seal they use, well, duh, you can't hide it. Right? The District Court of the United States is in the small claims court jurisdiction. That court has jurisdiction over small claims is the the District Court of the United States, not the United States District Court of the Western District of Michigan or of the District of Columbia or wherever the hell it is. Not that court. That court doesn't have jurisdiction. Right? That's not the District Court of the United States. There's only one of those. Right? And it has all these judicial districts. And so, I would say in my case that if we said that the name of the court is the District Court of the United States, then the venue jurisdiction would be District of Michigan, 84th Judicial District, or in my case, 63rd Judicial District. Right? But saying State of Michigan in all caps, that's about the same as, State of Michigan in all caps is common law. There was only one size letters to begin with, right? Later on, they made two size letters. But from the beginning, there was one size. You go look around Rome and all this old stuff, it's all uppercase, right? Uppercase is common law. So this is the common law state of Michigan, right? Which, if you read what they did in when they created the political subdivision or the political entity called the state of Michigan, right? That at the same time as doing that, they created this thing they called the District of Michigan. I really say that that's what this is. This is, like the federal state of Michigan. So regardless, hey, it'll all work itself out. I'm not going to, argue all the little facts with anybody. I'm just saying that this seal right here says the District Court of the United States, and that's a big deal. And so now this just got put in yesterday. Today, Tammy has to go meet the service process server, right, to give them the 2 copies that need to be mailed with these addresses to mail them. And, as long as they get delivered, there'll be a court date coming up. If you want to follow along, well, it's 84th District, case number 21-394-GC-2. Okay, well, that's enough of an introduction. I don't have any more time anyways. We'll just see where it leads. But, this is where the lesser magistrates are. and they have the seal of the big court. And they can bring the United States into court, make them answer to what happened to you. So, it's everything that this doctrine of the lesser magistrates was set up to be. Now we need to use it. All right, everybody have a great day. God bless. Bye-bye.